So good morning everyone. I'm really pleased to be here to take part in this important discussion on children's digital rights and regulating freedoms and safeguards. So thank you very much to Dr. Neil Lidging and to the Information Law and Policy Centre for the invitation to be with you this morning. I think the theme of today's conference and the focus on children as key stakeholders in the digital ecosystem is a particularly timely one as we look towards the 25th of May next year and the entry into the force of the GDPR across Europe. And as Lisa has already detailed in her presentation, for the first time we have a data protection law at EU level which lifts the veil of invisibility that some would say has hitherto shrouded child users of online and digital services. And as recent academic research has highlighted, an estimated 1/3 of internet users across the globe are under 18s. But as the Irish Society for the Prevention of Cruelty to Children has pointed out recently, those children are often operating in a world that wasn't originally designed with them in mind and still fails to recognise them as key players in the digital ecosystem. However, as we've heard from Lisa, from the 25th of May 2018, children are going to be very much at the front and centre of the data protection landscape in Europe. The GDPR will shine an unremitting spotlight on data controllers as regards safeguarding child users, who are attributed special protection under the new law. And when it comes to protecting children in the labyrinthine online and digital environments, enabling children to exercise their legal and their fundamental rights in a way that minimises the risks to them, all boils down to maximising their understanding of the cyber terrain that they inhabit as a large part of their daily lives. Lisa has already referred you to recital 38 of the GDPR, which states that children merit specific protection with regard to their personal data, as they may be less aware of the risks, consequences and safeguards concerned and their rights in relation to processing of data. And central to that whole issue of understandability and awareness is the obligation of transparency upon data controllers under the GDPR, which is what I wanted to focus particularly on this morning. So transparency under the GDPR isn't so much a brand new concept as more of a reconstructed and recalibrated obligation, albeit one that has now been shunted very much centre stage. Anyone who has ever gone online will be familiar with the concept of privacy policies or privacy statements on websites, in which data controllers are required to provide, under the obligation of fair processing, certain information under the current EU Data Protection Directive. That obligation of fair processing requires certain minimum information to be provided to the data subjects, including the fact of their data being processed, why the processing is happening, and who the data controller is. However, there have long been concerns about the utility of that limited information and if it truly enables data subjects to actually take control of their personal data. That's particularly so given that privacy policies and privacy statements have traditionally been expressed in lengthy, legalistic and specialist terms, which can be difficult for the average adult user to understand, let alone child users. The online world, with all of its permutations, is clearly an intrinsic part of children's everyday lives. And it seems that the age at which children start regularly accessing the web is becoming lower and lower. According to Ofcom, in a report last year, 3 to 4-year-olds are now spending an average of 8 hours and 18 minutes per week online. So 21st century children's use of online services is effectively ubiquitous, with many children now perhaps more digitally literate than their parents, sharing photos and videos, sending games, using social media platforms, and accessing entertainment amongst other activities. The issue of transparency in services which are targeted at children has long been a topic of global concern in the data protection sphere. The International Conference of Data Protection and Privacy Commissioners has issued a number of resolutions in recent years on children's online privacy and the need for educational initiatives. It has voiced concerns about the online encroachment into the private lives of children and the fact that children are often unaware that their information, their habits and their behaviour are being tracked online. And those types of concerns were illustrated by the results of the Global Privacy Enforcement Network's sweep from 2015, which Lisa has mentioned, and that included 29 data protection regulators from around the world, including the Irish Data Protection Commissioner as well as the ICO. And it examined websites and apps which were either targeted at or popular amongst children. And Lisa has detailed already how 41% of those websites and apps which were examined caused concern in relation to the collection and use of children's personal data. And I suppose particularly relevant to the issue of transparency were the statistics that the study revealed that although 67% of the sites and apps examined collected children's personal data, only 22% actually tailored their data protection communications to children. So that understandability gap in the information that data controllers must provide to individuals, particularly where those individuals are children, is what the newly enunciated transparency obligation under the GDPR seeks to address. The core transparency obligation can be found in Article 12, which requires data controllers to take appropriate measures to provide the required information to data subjects in a concise, intelligible and easily accessible form using clear and plain language. The specific information that has to be provided by a data controller to a data subject is now extensive, and it's set out in Articles 13 and 14. And it includes information about who the data controller is, how the personal data will be used, who it will be shared with, whether it will be transferred internationally, and very importantly, what the data subject's rights are. For example, the right to access, rectification, erasure of personal data, and the right to make a complaint with a data protection authority. And as far as providing information to and communicating with children is concerned, it's hugely significant that Article 12 carves out an explicit transparency obligation on data controllers for information which is addressed specifically to a child. And that ties in with Recital 58, which makes it clear that because children merit specific protection, any information and communication concerning processing of a child's data should be in such a clear and plain language that the child can easily understand it. So what does this new GDPR transparency obligation mean in practical terms for data controllers like those big companies that run the social media, the gaming, the messaging, and the photo sharing websites and apps that are so popular amongst children? Well, one of the most important phrases in Article 12 is the requirement that data controllers must take appropriate measures to provide the required information in that concise, transparent and easily accessible form. Article 12 specifies that the information must be in writing or by other means, including where appropriate by electronic means. So obviously the term appropriate measures is not a fixed benchmark, and the first step to a data controller ensuring that they deploy transparency measures which are appropriate to the ways in which they collect and process personal data from users of their services is that the data controller must know their audience. So if a data controller knows, as it should do, that its audience consists of or includes child users, then it must tailor its privacy information and its communications with its users so that child users can readily understand what is happening to their personal data and what their rights are. That means assessing what the most effective modality will be for conveying that information, considering the content and the accessibility of written statements, as well as the potential use of more visually based techniques such as cartoons, pictograms, infograms and videos. It also means considering the usefulness of tools such as layered information notices, pop-up notices, hover over notices and voice alerts. And of course, central to all of those considerations is the type of device that's being used, whether it's a tablet, a mobile phone or an Internet of Things device, including so-called smart or connected toys. So it's essential that the formats chosen for conveying the information are appropriate to the device that's being used by the child. And with written statements, the overriding requirement for clear and plain language means that privacy notices which are aimed at children must employ a vocabulary, a tone and style of language that is appropriate to and resonates with children. And that means no legalese, no technical terms, no jargon or ambiguous phrases that are devoid of any real meaning. But the Data Protection Transparency Challenge isn't just about ensuring that organisations provide information and communicate in a way that's understandable for children. Privacy education is obviously essential to encourage an awareness amongst children of what their personal data actually is, what their rights are, and what the risks are when they share their information online or digitally. No matter how accessibly or appealingly privacy information may be presented on a website or an app, it goes without saying that if children don't appreciate the significance of what that information is telling them, then the risk is that they'll swipe right past it without taking any notice of it. So perhaps the biggest transparency challenge is getting children to want to understand how and why their personal data is processed. And that challenge has to be embraced not only by data controllers, but also by data protection authorities, by policymakers, educators and parents, who all have vital roles to play when it comes to educating children and young people about their rights and risks online. The Children's Commissioner in England, in its Growing Up Digital Task Force report earlier this year, has called for the creation of a digital citizenship programme to be compulsory in every school from the age of 4 to 14. And similar sentiments have been echoed very recently in submissions made to an Irish Parliamentary Committee on Children and Youth Affairs in its examination of cyber safety issues for children and young people. Indeed, digital literacy is already a focus of many educational programmes, but in addition to taking account of the more high-profile risks around issues like cyberbullying and general online harassment, which attract a lot of attention, children also need to be educated about the perhaps more oblique risks arising from their personal data being collected in the digital ecosystem. So awareness of the need for transparency in data processing is growing, and societally we do seem to be moving in the right direction, particularly with the incoming GDPR obligations on transparency. But arguably, technology is currently winning the race over transparency in the privacy arena. There's a lot of catching up to do in fostering a culture where children, and indeed adults, expect and seek out transparent information from those organisations who collect, use and profit from personal data, so that children can make smart, informed choices about how and when and to what extent they choose to share their most invaluable asset, their personal data. Thank you very much.